Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. The Honorable Madam Justice Hennessy presiding. Long live the King. You may be seated. Unless done in accordance with the Superior Court of Justice protocol on the use of electronic devices, these proceedings are not to be recorded. Thank you.
Good morning, all. My first comment will be I have instructed the court registrar to record the proceedings. Good morning, all. We gather today on what has been called stage 3 of the Robinson Treaties annuities case. After stages 1 and 2, the matters were put over to stage 3. Can you all hear me? Yes. Were put over to stage 3 in a case management conference earlier this morning. It was agreed and on request, the trial of the Huron claim on the treaties annuities case has been adjourned without a date to be brought back on as necessary by the parties. Today we are starting with the Superior's claim, and there are interveners in this case. Those parties will all be made known to you as we proceed. My understanding today is that we will start with Mr. Schachter and Ms. Lewis from the Superior Plaintiffs.
Good morning. My name is Harley Schachter, and with Ms. Lewis, we represent White Sand and Red Rock and have a representative order in respect of a number of First Nations who we also represent. And there is a group of 7 who First Nations who are represented by Mr. Brian Gover. I have the privilege of providing an opening statement today, and I have handed up to the court and to my friends, both in hard copy and in electronically, an opening statement, which I want to make sure that the court has. No. I have been told and I reminded that there was to be an opening prayer. I was not aware. I apologize, and I'm not sure who is doing the opening prayer. Okay, well, we have it, and I will stand down.
My apologies as well. But I didn't see knowledge keeper Leroy.
Madam Justice, Ani Bonjour. Good morning, Mr. Koski. Better known knows what Mangan does, Mangan Gorum. In Kinamagan and Mumpy, this building that we are in is a place where I taught for 20 years, teaching Indigenous studies. In my first name that I said, my spirit name is North Facing Wolf, and I'm from the Wolf Clan, and my community is Michpekaten First Nation, and I'm honored to be here to share a prayer. But before I do that, as I stand in your canoe, and I say that because as I pass a bar, that bar, the railing on which you call the test to become a lawyer, is that which is a ship on which that law comes from, which is on Anishinaabeg land. As we acknowledge that we are on a Tikimikshing Anishinaabeg land, that this activity that we are in, that we share in that canoe, no canoe can move forward unless there is people on both sides paddling together. And that is the foundation of Anishinaabe teachings, is that we come together. And in that role that I have, in this presence that I have in this space, and as I honor Madam Justice, and how important it is that we learn together, that how important it is that we need to move together. And in our language, we understand the importance of not only the past and the present, but in order for us to move into the future, we cannot do that alone. And as we stand on this land at Tikimikshing as being the land of the Anishinaabe here, as well as the Wampate, but the land that we are all on as Anishinaabe, the land that connects us to the earth, the air, the water, the medicines that is here. The word for medicine in Ojibwe is mishkeke. I invite you to say that with me. Mishkeke. In there is the word earth twice. Ke. Mishkeke. When you stand on this land with both feet in a balanced way, you too become medicine. As we see the history in this land, as we understand when we share our prayers as we did in the sunrise this morning, how important it is that we return that balance. We have to understand where we are in the world today with climate change being what it is. It has not been with balance. These systems that we are in have not been with balance. And so I ask with the prayer, as we ask of the Creator to help guide us and understand that. And the 4 tools that we need is that we need to be quiet. Until we are quiet, we can't listen. And until we listen, we can't hear. And only after we hear will we be able to know where to move forward together. So ani jamdro, ani nok masak mashomasak chibay naro. Tinkanage go gashatoyen. Wewe na jamana gano wabak no wajibamaris. Meanwhile, wewe na gano. Migwich Giashkak Makwe, Gimijang Bamazuin, Gimijang Mijam, Gimijang Bish, Gimijang Wisiak, Gimijang Sakigan. Gimijang Babaram Lido. You went on those with Mangandas, Mangandoro, Mitch Bagwataran and Nojaba. Migwich Shawanam Lido. You went on those with Mangandas, Mangandoro, Mitch Bagwataran and Nojaba. Meanwhile, the Gishmak Gawi Nam Lido. You went on those with Mangandas, Mangandoro, Mitch Bagwataran and Nojaba. You went on the dope. You went on those with Mangandas, Mangandoro, Mitch Bagwataran and Nojaba. That last word, north, in our language, Giwedanang. Giwe means to go home. If we have family in this land, we all must go home to our hearts so that we understand why we are doing this. But if there are people without a home, we have to work to help them find that home. So I say Miigwech, Madam Justice. Oh, by the way, there's a sacred fire. If those that are present here, at any time you wish to go and attend, the fire keepers are there to greet you and to share some time and or prayers if you wish. So be good.
So I'd like to thank the elder for the prayer and the opening. And where I'd like to start is I do have a written opening statement. I provided hard copy to my friends. I've provided electronic copies to everybody. And where necessary, I have visual aids to my opening statement.
And I appreciate this. Thank you.
I call my opening statement Competing Visions on the Path to Reconciliation. And there's a reason for that, as we'll find out. This case started out as one of competing visions on the path to reconciliation, and it remains so. In stage 1, the plaintiffs put forward a vision of the augmentation clause that saw the treaty partners renew the covenant chain alliance. It was a vision where the treaty partners would journey along a shared path. It was a vision where the treaty partners would share future prosperity from 1850, and it would be shared into the future. The annuity would be augmented when there was wealth from the Robinson Superior Treaty territory. In contrast, the Crowns put forward what would later be described by the Ontario Court of Appeal as an impoverished vision of its responsibility. For the Crowns, instead of a shared path, the Crowns viewed the treaty as a one-time transaction for the sale of land on terms that did not require the Crowns to consider the wants, needs, or aspirations of the Anishinaabe. For the Crowns, there was no right to share in the bounty of the treaty territories, and there was no right to any increase from the same $4 that had been paid since 1875. One would have thought, indeed hoped, that the reasons authored by both this court in 2018 and by the Court of Appeal in 2021, by which the outstanding obligation to share the wealth from the treaty territory was confirmed, would have had some meaningful impact on the Crown's vision for the treaty relationship. Unfortunately, it has not. Regrettably, as we move to stage 3, the Crown's impoverished vision of its obligations remains. I have no doubt that in the coming days, you will hear from the Crowns that they profess both acceptance and embracement of the judgment and all that it requires of the Crown. And to use the words of the judgment, respect, responsibility, reciprocity, and renewal, and the intention of the Crowns to act honorably with justice or fairness and with liberality or benevolence. That's part of the judgment. Do not be fooled though, Madam Justice. The Crown's theories on how to implement the augmentation clause, both in the past and in the future, remain as impoverished as they ever were. But to begin our journey today, I want to return to important guiding principles that the Court of Appeal identified as being relevant for your deliberations. And that brings me to the second part, the outstanding judgment and the continued importance of both value and reciprocity. In 2018, this court ruled that the Anishinaabe were entitled to a fair share of the value of the Crown resource-based revenues from the territory. The Court of Appeal, in upholding the judgment, it did not like the word fair in fair share. I'm not sure why, but they didn't. But they embraced the idea that the goal was to share in the value of the resources. And I want to return to what they wrote about value. 288, at paragraph 288 of their judgment. The judgments provide that the treaties require the payment of annuities corresponding to a fair share of the value of the resources, including the lands and waters in the territory. We, this is the Court of Appeal speaking, we would deconstruct the judgments into two possible promises for analytical purposes. The first is that the augmentation clause was a promise to share in the value of the land. The second is that a fair share was promised. To paragraph 289, the first form of the promise, to share in the value of the land, is supported on the evidence and was woven through the trial judge's interpretation of the augmentation clause. Now, in seeking to provide guidance as to the meaning of value, the Court of Appeal turned to the principle of reciprocity and quoted from this court's reasons at paragraph 420 in the original stage 1 judgment. The Court of Appeal explained at paragraph 296, sharing was inherent in the Anishinaabe practice of gift giving and in the principle of reciprocity. The trial judge found that upon ceding their land to the Crown, the Anishinaabe chiefs and leaders had every reason to expect that their gift, and that's gift in quotation marks, attracted a reciprocal gift, again in quotation marks, commensurate with the value of what they had promised. And at page 306, that's right, paragraph 306, the Court of Appeal repeated part of this court's reasons, which are found at 470, that contain the following important words. A treaty that linked the future revenue of the territory to the annuities payable to the Anishinaabe answered the uncertainties and risks present. A revenue sharing model was consistent with the perspective that the Anishinaabe chiefs held about their relationships with the newcomers in the land. It was also consistent with the Anishinaabe's duties of responsibility as leaders towards their people. In addition, the sharing model invited renewal as circumstances changed. Most importantly, a sharing model was consistent with the principle of reciprocity. And finally, it is worth repeating paragraph 2 of the amended stage 1 trial judgment that reads as follows. A, the Robinson Superior Treaty was negotiated by the treaty partners around the Anishinaabe Council Fire at Bawatang, Sault Ste. Marie, as a renewal of the ongoing relationship between the Anishinaabe and the Crown, grounded in the Covenant Chain Alliance, and as a basis for continuing a mutually respectful and beneficial relationship going into the future. The treaty reflects the parties' common intention that their agreement was to allow both the Anishinaabe and the Crown to realize the future opportunities and potential, and I've highlighted potential, of the treaty territory in a manner consistent with the Anishinaabe principles of respect, responsibility, and I've highlighted reciprocity and renewal, and the intention of the Crown to act honorably with justice or fairness and with liberality or benevolence. So I want to emphasize 3 key takeaways that are really important as you hear the evidence in this stage 3. Firstly, the Court of Appeal agreed that sharing of the value of the treaty territory is central to the treaty promise. Secondly, the Court of Appeal endorsed the idea that reciprocity was fundamental to the treaty promise and that reciprocity is giving back an equivalent value to that which you give. Thirdly, the judgment expressly focuses on the goal of mutually respectful and beneficial relationships from 1850 onwards, and the focus is on the potential of the treaty territories, consistent with the principles of reciprocity, and not simply sharing a portion of what is left after the Crown gives away lands and resources or sells or leases lands and resources for much less than they could have charged or should have charged. These 3 takeaways are important as we go forward because neither Crown nor any of their experts consider how the principles of reciprocity and the importance of identifying the potential of the treaty territory, its value, inform the just determination of the compensation owed or the path to the future. The plaintiffs, however, have retained experts to examine the potential of the treaty territory with due regard to the principle of reciprocity. The plaintiffs' experts thus examined the worth or value of the resources that the Crown actually took out. You will come to hear that this is called the resource rents approach. And it is the only approach you will hear that provides data and information and guidance as to how reciprocity, value, and potential fit into the determination of just compensation. Now, before I can go on any further, it occurs to me that many tuning in online or watching in person have only a passing knowledge of this case. And I note that it's been about 5 years since the evidence was led in this before this court in stage 1. So before I turn to the evidence that you will hear that I think is critical to this case, I want to spend a few moments discussing the past. Doing so will help to remind us where we have been, and it'll set the stage for the task this court is about to embark on, remedying a historic treaty breach dating back over 170 years. So I begin prior to 1850, and prior to 1850, the Crown recognized the Anishinaabe as the proprietors of the soil. Now, we now call that in legal terms unextinguished Aboriginal title. To the Anishinaabe, the land is a living part of interconnected relations. The people had responsibilities towards the land, and the land in turn sustained the people and was meant to sustain future generations. in the treaty territory, or what was to become the treaty territory, by 1845, there was a widely held perception that the area that would become the treaty territory contained great mineral wealth and would be a source of long-term prosperity. The Crown, alive to the prospect of great riches, wanted to secure the right to both access and to exploit those resources. But without a treaty, the Crown had no rights to use the lands and resources within Anishinaabe territory. The Royal Proclamation of 1763, however, provided the Crown with a roadmap to secure those rights. And among the proclamation's terms was an approved treaty-making process by which the government could secure those rights. They could secure it not by conquest, not by some manifest destiny, but by treaty, by agreement, by solemn covenant with the Anishinaabe. Prior to 1850, during 1846 to 1850, various Anishinaabe chiefs met with Crown officials to discuss the possibility of entering into a treaty. But the Anishinaabe did not want to share their lands for a paltry annuity. Oh no. The Anishinaabe explained to the Crown officials with whom they would meet, they wanted to share the wealth from the treaty territory. Referring to the mining industry, Chief Shingwakons famously demanded that he saw men with large hammers coming to break open my treasures to make themselves rich. I want to stay and watch them and get my share. Now, the Anishinaabe may not have had the mining tools that were available to the newcomers. May not have had the mining tools that were available to the newcomers, but that was no impediment to Anishinaabe. Absent treaties paying them their share of the wealth, the Anishinaabe were prepared to, and they had in fact entered into what could be described as joint venture relationships with others to exploit the resources still belonging to them. And the court might remember in stage one, there was the evidence of Mac Donnell entering into an arrangement with Shingwakons to do some mining and to share the wealth. But the Anishinaabe also were in the habit of imposing tolls on those people going through their territory. But the Crown was insistent. Colonial laws in force at the time only permitted the Anishinaabe to work with one partner, the Crown. And so it was to be. In 1849, the Crown considered what treaty terms to propose to the Anishinaabe, and a problem arose. From the Crown's perspective, the Anishinaabe placed too high a value on the land, and unlike in past treaties, the Anishinaabe wanted to share in the future wealth. Now, as discussed earlier, Chief Shingwakons demanded pay for every pound, referring to a share of all that came from his land. Similarly, the chief of Fort William, Podeshat, likewise demanded that he must know what the land is worth. He must have something for the minerals taken from his land, as well as a share of what remains. Meanwhile, the Crown had little cash available to treat with the Anishinaabe. In 1849, following meetings with the Anishinaabe, Commissioners Vidal and Anderson, who had been sent to meet with the Anishinaabe, recognizing the demands of the Anishinaabe to share the wealth, seized upon the solution. In their 1849 report, the commissioners observed that little was known of the value of the so-called vast and sterile territory, as the way it had been described. So Vidal and Anderson recommended a provision could be inserted into the upcoming treaty, and to use their words, if necessary, for an increase in the amount of the annuity upon further discovery and development of any new source of wealth. Well, that Vidal Anderson 1849 report was sent along to William Benjamin Robinson, Robinson met with the Anishinaabe in August and September of 1850 at the council fire, and treaty terms were concluded. Now, it is important to understand, as this court did in stage one, that a treaty is not a one-time purchase and sale document as though one person is buying a car from another. It's a relationship agreement, and this makes all the difference as we start examining stage three and what all it imports. It's a relationship agreement by which the parties intend to continue to live and thrive side by side for all time, sharing prosperity as and when it comes into existence. As the evidence in stage one made clear, in 1850, the Crown had limited cash to which to entice the Anishinaabe to enter into a treaty. But this problem could, quite frankly, be easily dealt with, and was. It could be overcome because both the Crown and the Anishinaabe were in agreement on the key to making a treaty. Both Crown and the Anishinaabe were prepared to live with and embrace a small annuity to start, an annuity that was roughly 16% of what the other nations were receiving for a full surrender. If you take $10 being the standard payment on a per capita basis, and if you take the 500 pounds that the annuity gave to the Robinson Superior, you divide it by the 1,240 people. This is at footnote 9 on my opening remarks. It's $1.61 or $1.60 per person, excuse me. So roughly 16%. So that gives you a sense that the Anishinaabe took 16% of what the Crown thought, not the Anishinaabe, but what the Crown thought would be a full payment. That gives you a sense of, and if I can say so, a foreshadowing that the sharing of the risk back in 1850 is simply 84% Anishinaabe, 16% Crown. We will hear from experts on that. And the promise was that as and when there was a future wealth to be shared, the collective annuity would increase. Now, I expect that most in this room know the treaty terms well, but those who might be hearing it for the first time, it's worthwhile repeating what was put down in writing by Robinson. After Robinson set out there was supposed to be a starting annuity payable to the collective of 500 pounds, which is equal to $2,000 as we would know it. The operative words of the treaty continue as follows. The said William Benjamin Robinson, on behalf of Her Majesty, who desires to deal liberally and justly with all her subjects, further promises and agrees that in case the treaty territory shall at any future period produce an amount which will enable the government of this promise, without incurring loss, to increase the annuity hereby secured to them, then and in that case, the same, referring to the annuity, shall be augmented from time to time. Not may be augmented, not at the discretion of the Crown would be augmented, but shall be augmented. Now, those are powerful words indeed, and a shared vision, I might say, for a joint and prosperous future. That was just the type of joint venture the Anishinaabe sought. They would share the wealth with the newcomers. The common intention then from 1850, from the very start of this treaty, was that the Anishinaabe and the Crown would embark on what can fairly be described as a joint venture and a path to prosperity for all. On this score, the trial judgment from stage one, which I've already referred to, as affirmed by the Court of Appeal, could not have been clearer that the purpose of the treaty was to share the wealth into the future. Remember, the judgment focuses on mutually respectful and beneficial relationships that ensure a sharing of future wealth and potential of the treaty territory with reciprocity at its core. But alas, as history tells us, no sooner had the promise been made that Crown administrations conveniently forgot the promise. The Victorian era was in full swing. Canada came to be populated by more and more non-Indigenous people, people who had no memory of the promises of 1850. The next 100 years were hard ones for the Anishinaabe. They faced, and some would say still faced, racist government policies, their hunting and fishing rights ignored, forced to endure the ravages of the residential school experience. The Crown Commission empowered to investigate residential schools, the Truth and Reconciliation Commission, described that experience as genocide, cultural genocide. The Anishinaabe survived, but they did not thrive as they should have. They were marginalized and pushed to the side, and the Anishinaabe were given little space in the lands that the Anishinaabe so honorably and that the Anishinaabe so generously agreed to share with the European. Now, we are here today because it is just that the promises to the Robinson Superior Treaty beneficiaries be honored. They must be paid for the wrongs of the past, and they must be able to share in future prosperity. The Anishinaabe are partners in this great experiment we call Confederation, must have access to the opportunities and resources that many of us take for granted as our birthright. A birthright that is only made possible by the agreement made in 1850 with the Anishinaabe. In 2005, I might remind everyone that Justice Binney of the Supreme Court of Canada, in an important case called Mikisew, wrote at paragraph 1, the fundamental objective of the modern law of Aboriginal and treaty rights is the reconciliation of Aboriginal peoples and non-Aboriginal peoples and their respective claims, interests, and ambitions. The management of these relationships takes place in a shadow of a long history of grievances and misunderstandings. The multitude of smaller grievances created by the indifference of some government officials to Aboriginal people's concerns and the lack of respect inherent in that indifference has been as destructive of the process of reconciliation as some of the larger and more explosive controversies. And so it is in this case, he said. And so it is, unfortunately, in this case as well. And with that, we come to the present. A mutually respectful and beneficial relationship going forward is what the parties agreed to, and ultimately it will be what we are going to ask the court to order. The majority of the Ontario Court of Appeal confirmed this court's view that the treaty creates a revenue sharing model and cited with approval the court's finding that a plan to share the wealth on an if and when basis through an augmentation clause was central to the understanding, the aspiration, and intent of both the Anishinaabe and the Crown. And I want to pause here for a moment, because the idea of the if and when or wait and see approach to increased annuities is going to figure very, very importantly in the just disposition of this case, because some of the experts have ignored it in its entirety in favor of a different vision of the treaty, a vision that has no basis in historical fact. So as I see it then, there's really three issues that at stage 3, this court is going to be asked to deal with. And I list them at paragraph 43. Firstly, what is the amount of compensation payable to the Robinson Superior Treaty beneficiaries in respect of the past failure of the Crown to augment the annuity in accordance with its terms? And I want to pause here to make an important observation about the claim to past compensation. What the Anishinaabe lost is the opportunity to participate in the process. They did not simply lose a set amount of annuities. Their loss is not stacking up the annuities and putting them in a band trust account. That's not what it is. It's not the actual past annuities that their claim is. Their claim is about the lost opportunity to influence and to receive the proper share of the value. And
Sorry, when you
Yes.
say a lost opportunity to participate in the process,
yes,
was your last statement perhaps a definition of what that process is that you're referring to? Are you saying the process to determine how to manage the resources, or the process to determine how to compute the value?
the process to determine what the annuities would be is the process that would examine, and hopefully in the future will examine, what it would entail discussion of such things as how are we together as treaty partners going to exploit the resources? What resources are we going to exploit? How are we going to extract the value? Is it going to come out all in stumpage fees, or are we going to have a low stumpage fee and maybe recover it back in some other way through a royalty or through a corporate tax? Those discussions didn't happen. That ability of the Anishinaabe to be partners in defining how the wealth would come out never happened. And it is that lost opportunity that we are going to be asking the court to consider when we talk about past compensation. The second question then is, what are the principles that the court can provide for implementing the treaty on a go-forward basis? Thirdly, are the federal and provincial crowns jointly and severally liable to fulfill the treaty terms, as we say? And as between the crowns, how is that liability to be divided? And you will hear much from the crowns on that, but to a great extent, so long as the crown at large is responsible to the Robinson Superior Plaintiffs, much like in the Privy Council considered back in 1896, it shouldn't matter to us. Our assurance should be the same either way. And the easiest way to make that assurance is at this stage, given what has happened with Confederation in 1867, is to make them jointly and severally liable. But I don't want to get into argument about that right now, but that's going to be our position. Now, before providing you with the plaintiff's answers to two of the three questions, because I've already answered one of them, I want a few words are appropriate concerning how resources were extracted in the past and how the experts deal with this data. So I want to sort of set the stage. The past exploitation of the treaty territory resources. Since 1850, the promise to share and the requirement to consult and take into account the interests of the Anishinaabe through that engagement process have been ignored. The Crown has made decisions about how and which natural resources would be exploited and decided on its own without regard to the interests of its treaty partners, the Anishinaabe, to whom the benefits, without the discussion or without regard to the interests of the Anishinaabe, the Crown would decide to whom the benefits of those natural resources would flow, how they would flow, and what revenues the Crown would take. In the past 173 years, the value of the resources taken out of the treaty territory by the Crown have been taken out in many different ways. Some were taken out as direct Crown revenues paid by resource extractors to the Crown. by way of such things as stumpage fee or royalties or crown leases, but other times the value of the resources were simply given away, such as free grants of land or effectively transferred to corporate interests by way of grants or subsidies to industry. Now, to be fair, the Crown did not give away wealth without purpose. It did so knowing that it would later reap the benefits of taxes, levies, or charges that it would impose on economic activity within the treaty territory. In this way, the Crown effectively recaptures part of the value of the natural resources that it gave away or leased out for less than what it was worth. Of course, no one, well, perhaps no one other than the Crown defendant, in this case, Ontario, would think it fair and just for a partner in a joint venture to give away all or some of the value of the resource, and then to tell the Anishinaabe that the aggregate net value of the resources extracted over the last 173 years is zero, and there is no wealth to share at all. But that is what you will hear Ontario's experts say. They will advocate for, and just to give you a foreshadowing, that there's actually up to a negative $11 billion amount that it's been worth, the land has been worthless to Ontario since 1850, or since Ontario took over in 1867. In undertaking the task of identifying the proper compensation to be paid and the principles for the future, this court must not lose sight of what the Court of Appeal reasoned at paragraph 89. Remember at paragraph 89 that there was a promise, they confirmed there was a promise to share in the value of the land, which promise was supported on the evidence and was woven through the trial judge's interpretation of the augmentation clause. Nor should the court forget about the animating principle of reciprocity that guides the implementation of the treaty promise. And to repeat again at paragraph 296, because I can't emphasize the importance of value and reciprocity, this court's observation at 420 of stage 1, the Anishinaabe chiefs and leaders had every reason to expect that their gift attracted a reciprocal gift commensurate with the value. This state of affairs of Ontario and Canada not keeping track of the value as it was taken out leaves this court the heady task of unscrambling the omelet to ensure that the compensation in the past and the principles for the future reflect the common intention found to exist in 1850, that the annuity would reflect an appropriate share of the Crown resource wealth consistent with reciprocity, fairness, justice, and the honor of the Crown. With this, I want to turn to a summary of the various experts' conclusions. Now, here is where I turn to my first aid. If you'll just turn up for a moment, tab A. Tab A is the Coles notes, if you will, of everybody's experts reports. And what I've tried to do in 3 sheets is try and summarize everybody's analysis. And as you can see, just by looking at Appendix A, there's a number of variables. There's the nominal amounts, the net nominal amounts, and the experts have done it from 1850 to 2019. That's the first point. And then they've brought it forward, all the experts, to March 2020. So it's not a complete figure, but you've got the nominal amounts, which is adding up the actual amounts in each year. And you'll see that it goes from Hutchins and Stiglitz at 1.044, and that's in billions of dollars, and up to 3.58 for the rental approach And if you go over on the next page, the amount, the nominal amount for the income gap approach suggested by the Court of Appeal is even higher, 5.5 billion. And then you have the various approaches taken by Canada's expert, Booth and Kersner, who used an earlier version of Hutchings and Stiglitz. Hutchings and Stiglitz originally were at 1.1 billion, but then there was, because of the mapping changes and the like, it got reduced to 1.044. But in their analysis, Booth and Kersner just had accepted Hutchings and Stiglitz net Crown amount. And you'll see Bodway and Smart are in the negative 1.8 million. And that's without bringing the amounts forward. And then to the right of the nominal amounts, you'll see what is basically the three different opinions about how to bring those losses forward. And they seem to be three different percentage rates, and we will get into that in a moment. But I just wanted to let you know that as we go through this, you can check off as the witnesses testify from that tab A. It'll be a helpful guide to sort of say, okay, this is where this comes from. And it may even actually help you, define some questions for counsel or the experts. Now, when examining the Crown resource-based revenues, all experts confine themselves to 5 categories of revenue streams. Mining, and here I'm back at paragraph 53 of my opening statement. Mining, forestry, hydropower, land dispositions, and spectrum. More sources could have been looked into, but all the experts seem to have agreed that those 5 are the big ticket items that one could focus on. And as a matter of practicality, we can't just go for every single source. It would just make this trial unmanageable. And with only 5 variables, I'm hoping it's manageable. I indicate that I have provided the chart, and the range in the chart that I just referred to takes us anywhere from, on present day dollars, anywhere from Ontario's negative 11.9 billion. So just to sort of put that in perspective, that would mean that Ontario might say to the Anishinaabe, look at over the past 173 years, we've lost 11.983 billion. And so you should pay us for the privilege of having taken your land from you. That's one way of that Ontario, you could characterize Ontario's vision. Or it goes actually to as high as 193 billion using the relative wealth and needs approach suggested by the Court of Appeal. That's Stiglitz and Hutchings on the second page of Part A. It goes up to 193 billion. So the results vary dramatically on whether one tries to capture the whole of the benefits taken by the Crown that were generated by the natural resources extracted. And those amounts are included in resource rents, or whether one confines themselves to taking into account only the direct Crown resource-based revenues that the Crown chose to receive for the use of the resources by industry, such as stumpage. Now, that amount is a much smaller amount. Or thirdly, whether one wants to use the income gap approach suggested by the Court of Appeal. Further, each analysis varies dramatically in result, depending on how amounts are brought forward to 2020 dollars. The results vary widely depending on one uses only a long-term bond rate, the Indian band trust account rates, or as Stiglitz and Hutchings do, a conservative commercial rate, or in the case of Booth and Kersner, a mix of inflation rate, band trust rates, and some rate that serves as a proxy to account for their acknowledgement that spending money on such things as education and health effectively are investments that have rates of return for the future. Looking at the wide range of opinions, Madam Justice, one might think that the court is going to be inundated with vastly different data sets and vastly different opinions on what counts and what does not count for past compensation. But thankfully, as the evidence is presented, we believe that the issues separating the parties fall into 5 main areas of disagreement. And I pause before getting to those 5 points to say that one of the areas of disagreement, one of the areas of agreement, or at least where the parties are very close on, is what are the net direct Crown resource-based revenues. So how much the revenues are, Stiglitz and Hutchings say it's 1.044 billion net, but the gross amount does not appear to be that much different among the experts. So the wide range of calculations among the experts from our perspective, the plaintiff's perspective, fall into 4 main differences. Firstly, the role of reciprocity, value, and potential in the assessment of compensation. As I noted earlier, our experts have determined what the value of the Crown-based natural resource revenues actually historically extracted have been. And their net amount is $3.58 billion over the years. The other experts simply reject the relevance of reciprocity and value. It's not included in their examination. The second major point of disagreement is if you calculate the direct net Crown resource revenues, that's NCRRs, what expenses count? And here there's another fundamental disagreement between the experts, and it's that Ontario's approach is that Ontario counts expenses not only that support the revenues produced, but supports resource rents. Even though Ontario only counts the direct resource revenues. In other words, Ontario's experts take into account expenses that not only result in revenues for the Crown, but are also incurred for other purposes and generate benefits and revenues that Ontario says the Anishinaabe are not entitled to share in. In contrast, our experts, Stiglitz and Hutchings, count expenses that relate to collecting, regulating, and supporting relevant revenues. In other words, our experts insist on a matching of revenues and expenses. To be counted as an expense, our experts say the expense must be incurred with the reasonable prospect that the expenditure will result in the existence of shareable revenues. That connection, or whether it should be a connection, is a point of disagreement between the experts. The third major point of variance is the treatment of risk. And this one is hard to spot as you go through the experts' reports, and you're going to need to really, it needs to be unpacked. Let's put it that way. The if and when future approach to future argumentation was at the core of the treaty bargain. And this is why I spent a little bit of time at the beginning about the if and when approach. And this approach carries with it low risk for the Crown, but it's rejected by Ontario. Ontario's experts approach the treaty bargain as though it was an 1851 time sale of land. And so this characterization resulted in them thinking of the treaty as a one-time bargain and then asking themselves the mathematical question, well, if I'm sitting in 1850, given what I know has been produced from this land, what's the discount rate that I would apply? The inevitable mathematical result is that the appropriate share of the resources revenues payable to the Anishinaabe decreases each year from 1850, reaching a 50% share by 1877, and continuing to reduce each year such that by 1911, the share is only 20. And in 2019, it's 1%. And in 2020, it'll be even less and less and less. And a graph showing you the effect of the Bodway and Smart approach is attached in Appendix B. And I want you to pull that up if you could for a moment. And you can see the effect of the sharing of the net crown revenues, how it decreases. I guess that's, it's not, is it geometric or inverse geometric, or I'm not sure. My math ain't so good, but I can tell you, I see.
Maybe it's your vocabulary.
Yes, my vocabulary is probably even worse. But what's happened here is that by, I would say that Bodway and Smart have constructed a counterfactual world that doesn't exist. And this has allowed them to use math to come up with a very palatable to Ontario result, minus $11 billion. And you can see, if you can well imagine, that if my clients are getting or entitled to less than 20% in 1911 and 1% now, but the expenses keep on going up, you're going to have negative amounts in every year. And that's what their data shows. Their data says, well, if you assume this risk adjustment approach, there's never anything to share with the Anishinaabe. It's a false analogy. The proper analogy is to treat what happened in 1850 as the if and when model. And the plaintiffs' experts will explain that the if and when model results in the majority of the future risk following 1850 being borne by the Anishinaabe. And so then that brings us to the fourth major area of dispute. And what is the appropriate share for the Anishinaabe? Now, as I have already indicated, the experts vary in opinion as to what the Anishinaabe share should be. And it seems to vary from Bodway and Smart's reducing share over time, which I said now sits at less than 1%, to the Stiglitz and Hutchings 84% joint venture model, which reflects the relative risks of the parties back in 1850. Fifth item, what is the time value of money? This variable has the most dramatic result on the outcome of the quantification. Save for Booth and Kersner, who I've already indicated, delve into an analysis of rates of return on consumption and adjust only a portion for inflation. The parties seem to be in agreement that the average rates over the long haul for the various rates of return are 5% for long-term bonds, 5.3% for band trust account rates, and for the 60-40 equity debt rate, 7.2%. Now, of course, the experts disagree on what the appropriate compounding rate ought to be. And as one can see from the enclosed chart, tab A, even a few percentage points between 5 and 7% over a long period make a significant difference. That's the nature of the difference. Now, before leaving the discussion of the various experts' conclusions, I want to make two additional observations. You will note that in my chart, I did not insert in an alternate approach to compensation put forward by Bodway and Smart. Their alternate approach is respectfully a thinly veiled reworking, which I would call statisticulation, of the data they use so as to present a more palatable result for the court instead of the uncredible conclusion that the resources within the treaty territory have zero value or negative $11 billion. The court should not be fooled. Like their main approach, the alternate approach is flawed. Now, and again, perspective is everything, because their alternate approach says, well, the Anishinaabe are entitled over the last 173 years to $34.7 million in aggregate. That's what their conclusion is. Now, to put that amount in perspective, because of the time value of money, if you took a one-time payment of $286.38 in 1850, and you ran that for 173 years, you'd have $34.7 million at 7%. That's my footnote 17. Just to keep things in perspective. So, you know, the numbers are large, but they're large because of time. There's a second caveat to Ontario's alternate approach. They mislabel it as the Vidal-Anderson approach. In truth, this alternate approach has nothing to do with Vidal and Anderson and is antithetical to Vidal and Anderson's wait and see approach. Now, in my mind, it is plain that Ontario seeks to imbue their alternate approach with some sort of historical credibility by giving it a name that does disservice to the two gentlemen, Vidal and Anderson, who so steadfastly embraced the concept of sharing any new sources of wealth. Secondly, a note on the amounts at issue. There is no doubt that, save for the Bodway and Smart theory that the lands are worthless to the Crown and have been worthless for 173 years, and thus entitled the Anishinaabe to nothing, the amounts at issue are large in absolute terms. Now, considering that we are talking about 173 years of non-payment, the net nominal amounts related to revenues, which top up at 3.58 billion, actually reflect a conservative calculation. In nominal terms, after 173 years, it's really on average 20.8 million per year for the whole of the treaty territory. It's not so unreasonable. Yes, the final amounts claimed as payable are large, but this is because of the time value of money. They are large because the Crown did not honor the treaty obligation. They are large, but they are not untoward. With that, I want to turn to the witnesses you will hear from. Does the court want a break?
Well, why don't we talk about when it would be appropriate to take a break? It's 11:30, I think. Came back to this room around. What do you think is reasonable?
Well, we can, I've got about an hour and 20 minutes left. Well, there it is. With an hour and 20 minutes left, would you like to take a break? And Mr. Gover has a brief opening as well.
About 20 minutes. Well, at some point, we're going to need a longer break than 15 or 20 minutes.
Right.
So when is the best time to take that break?
Well, it's 11:30. I'm in the court's hands. I'm okay with anything.
Why don't we take a break around noon or 12:15?
Yes.
Or an hour? I'm not sure
Yeah.
what arrangements people have made to give themselves nourishment, sustenance. But is an hour sufficient, or do we need an hour?
I would think we would only need an hour.
Today, I think an hour would be suitable, perhaps.
Yeah.
On other days. Talk about scheduling, if I can make a suggestion.
Yeah.
Because it's hard to find food nearby, I think it'd be better if we could have a bit longer for lunch. We'll probably have to drive to get it. So I'm saying an hour and a half.
So then we'll take so why don't we take a break around 12:15 for an hour and a half? And whatever you have to finish after that break, or Mr. Shacker, you let me know when around that time would be a good time for a break. and
Yeah,
we'll
I'll keep my eye on the watch.
finish you and then Mr. Gover after that. I think you're right, Ms. Evans. I don't think it'll be quick unless you make prior arrangements for delivery.
They don't allow us into the cafeteria? No, I thought there was a cafeteria. No, there's more than. There's a lovely cafeteria around the corner, and there's a Tim Hortons I found out this morning that's also available, but
It'll take a walk. Why don't
yeah.
we'll try that today.
Okay, I don't want to lose my cadence, so look at. I want to talk about the witnesses you will hear from.
Okay.
So first off is Professor Joseph Stiglitz. Now, in addition to winning the Nobel Prize twice, you will find out from his impressive 145-page CV, it's the biggest CV I have ever seen in all my life, includes such things as being a noted author and numerous celebrated and awarded books. He is a consultant to presidents and governments across the world and served as the chief economist of the World Bank. To coin a phrase, if one was faced with a haunting in New York, one would call Ghostbusters. But if you have a problem in economics, who are you going to call? Joe Stiglitz. So, what will our esteemed professor explain for us? He will explain that there is a widely known and widely accepted methodology to calculate the value of the resources taken out over the last 173 years. It is called calculating resource rents. He will explain how he, together with economist David Hutchings, who we worked with, in a most conservative manner that underestimates the value of the actual natural resources extracted over time, can identify what the value of the natural resources taken out were. This is important because it is the actual value that informs the principle of reciprocity and the common intention to sharing the value and the potential of the treaty territory that is at the heart of the treaty promise. Professor Stiglitz will speak to the principles by which resource rents are identified and valued, and David Hutchings will then do the calculations. A second part of Professor Stiglitz's testimony will focus on the economic principles that inform how to determine the sharing as between treaty parties. A third part of his testimony will deal with the relative wealth and needs of the Anishinaabe and the settlers, which, as you will recall, was a consideration that the Court of Appeal thought appropriate to consider. The calculation of the relative wealth and needs of the Anishinaabe over time, as directed by the Court of Appeal, does not focus on a share of the value of the resource rents of what was extracted. It does not focus on a share of the smaller portion of those rents that the Crowns chose to realize directly from the treaty territory, the NCRR approach. It focuses on the relative wealth and needs over time of a specific population. Of course, in order to know what those disparities were over time, one needs to understand what the cohort or population numbers of the Robinson Superior Treaty beneficiary population was from time to time. While neither Crown has any theory disputing the methodology used by Stiglitz and Hutchings in quantifying what has been called the income gap approach, the Crowns challenge our expert opinions on that basis on two grounds that I wanted to discuss. Firstly, both Crowns dispute the bring forward calculations used by Stiglitz and Hutchings. Now, as part of the chart at tab A makes clear, the difference of opinion makes the range of past compensation under this head vary from as low as not 31 billion to as high as 193 billion, just on a couple percentage points. The second challenge raised by Ontario alone, at least I believe it's by Ontario alone, I don't think Canada joins them in this. If Canada wants to join them in this defense, they'll say so, is that the only cohort of population that Ontario says matters is the cohort that's presently alive. In other words, Ontario says that the dead are irrelevant. We will urge the court not to accept this limitation for a number of reasons, and the evidence you will hear will support a number of propositions. Firstly, it would be wrong to suggest that the dead do not matter. Aside from being morally indefensible, if past lives do not count, then the Crowns get a financial windfall with each band member who dies, and it would incentivize delay in implementation, as delay would reduce the Crown's financial obligations. Surely, this is contrary to public policy in the honor of the Crown. Second point, to accede to the view that only the present cohort alive today matters would effectively hand back to the Crowns more than they would be entitled to had the limitations defense been successful. A limitations defense that Canada never pleaded, and a limitations defense rejected by this court and the Court of Appeal. I use the word more, they would get back more, because even if there were a limitations defense of the 20 years that originally Ontario argued for in stage 3, the proper population cohort would not be those alive now, but the cohort alive from 1981, 20 years before the original claim was filed, sorry, I can't do my math, 1979, 20 years from before the original claim was filed in 1999, not the current population. Thirdly, it must be remembered that while the calculation of relative disparity over time had to, of necessity, aggregate the disparity on a per capita basis, the annuity entitlement has been and remains a collective entitlement. And the beneficiaries are the Anishinaabe Nation, which nation was alive in 1850 and continues to be alive today. It is their loss going back to 1850 that matters. Fourthly, and as our experts will opine, the historical income gap analysis provides context and insight into the accumulated persistent deprivation experienced by the Anishinaabe. Like financial wealth, societal wealth and well-being is a function of the incomes, health, education, and welfare of individuals in the past, and thus past gaps have current consequences and must be taken into account. It's not as simply as saying you just have to worry about the present population. A fourth part of Professor Stiglitz's testimony will explain how to properly deal with the time value of money and how one might properly bring forward the historic losses. His conclusion is that the proper measure is a conservative commercial-like portfolio. In a nutshell, this approach is proper because the Anishinaabe people are equal and not inferior to non-Aboriginal people. At the end of the day, we should expect that if the Anishinaabe had been told in 1855 that there were vast funds available for them to invest, they would have done the very same thing they did with Macdonnell in 1840s. They would have hired and sought the guidance of experts who could help them. We will explore why, and the evidence will show that the federal government's fixation in this case, as in others, to examine the spending patterns over time of some of the Anishinaabe First Nations lacks fundamental probative value. It lacks value because a nation's spending habits when it has $100 to spend will be vastly different than when it has billions to spend. And I was trying to think of an example, and so I came up with this. Imagine, if you will, young Rob Walton, excuse me. Rob Walton, the son. Rob Walton is the actual son of Sam Walton, the billionaire founder of Walmart. Now imagine he likes coffee. He works at his dad's store in the early years. He gets paid $1 a day. Each day he goes into the local coffee shop, their version of Tim Hortons or Starbucks or whatever it might be, and he buys his $1 cup of coffee. It's his routine. It's his spending pattern. The next week, he gets the same $1 from work, but he also gets $1 million dividend from the Walmart stock he owns. Not surprisingly, Rob Walton does not go into the coffee shop and buy 1 million cups of coffee. He spends $1 on coffee and he invests the balance. So that's a good example, I think, of how you can't really put too much weight in spending patterns when you have large sums of money that come in. Things change. Finally, it's expected that Professor Stiglitz will address some of the Crown's experts' errors made by their experts that he and Hutchings have identified. And those errors are discussed in the Hutchings and Stiglitz joint reply report. That brings me to my second witness. It's going to be David Hutchings, his economist. Now, our second witness will be an economist, David Hutchings. Mr. Hutchings has a Bachelor of Science in Economics, Bachelor of Science in Mathematics from the Massachusetts Institutes of Technology, and an MA in Economics and a law degree from the University of Toronto. He specializes in conducting economic analysis of complex transactions. And from his resume, it seems that when the IRS of the United States of America has a problem, it's his name that comes up when you on the current version of what I used to have, a Rolodex. And if you turn up to, for those listening who are younger than 30, at Appendix C is what a Rolodex is. And that's what I used to use. In addition to co-authoring the reports with Professor Stiglitz, Mr. Hutchings had the task of applying the data to the value principles enunciated, and he will explain how the numbers are calculated and the data, he will explain the data set he used. The figures he arrives at are a net nominal value of resource rents of 3.58 billion for the period 1850 to 2019. Mr. Hutchings also explained and examined the data needed to identify the direct gross Crown resource land revenues, and then he examined what the relevant appropriate expenses should be to be deducted. He arrived at a nominal net Crown resource-based revenue amount for the same period, 1850 to 2019, of 1.044 billion for the whole of the period, and he will explain how he got to that number. Now, he will explain that while the Crown could have benefited up to the tune of 3.5 billion over the years if it ensured that all economic rents from the resource actually extracted were captured based on a conservative analysis of those rents. For whatever reasons, the Crown, he can calculate, took out only 1.044 billion in a direct way. Like Professor Stiglitz, Mr. Hutchings will explain that if you want, yeah, yes.
Schechter, is that 1.044 billion, is that number you say is almost agreed upon by the parties?
No, that's a net amount. That takes the gross,
net.
yeah, that you take the gross and then the expenses. It's the gross revenues that the parties are very close on.
Thank you.
Yeah.
I see that.
Yeah.
Thank you.
Like Professor Stiglitz, Mr. Hutchins will explain, if you want to accurately identify all direct and indirect aspects of Crown resource wealth actually received, one would have to add to the 1.044 billion some portion of the 3.58 billion amount, or so, as some or all of this difference, which is still attributable to resource rents, would have been recaptured by the Crown in the form of other revenue streams. Now, I want to pause here because I think I may have understated, or I'm not sure if it's overstated, but when we talk about taxes or under other indirect revenue streams being recaptured, the $3.58 billion amount net does not try to recapture the taxes. It's an estimate not counting taxes. And that's made clear in Stiglitz and Hutchins' report. So if you included in the actual amounts of resource rents, and you wanted to fold back in that portion of resource rents attributable to taxes, corporate taxes, income taxes, and the like, it would be greater than 3.58 billion. So when you listen to the evidence, please keep in mind that the 3.58 billion is a very conservative valuation of the rents. The second point about the rental approach is that maybe it's not intuitive when you read the report or when you think about it, but the 3.58 billion is not a measure of the revenues that the Crown could have taken out of the territory if it wanted to maximize resource extraction. That number would actually be many multiples the 3.58 billion. And it's not a number we're asking the court to consider. And it seems that many who I've talked to, who have either read the reports or who know a little bit about the case, have said, well, Harley, that's just a what if they took out all the resources they could take. That's not what the rental approach is. The rental approach is saying, let's take a look at what actually came out of the territory, and let's value what actually came out, not what could have come out, not what the Crown might have wanted to come out, or what the Crown and the Anishinaabe, if they had sat down, said, you know what, let's have more hydropower, or let's extract more minerals from Sudbury at a faster rate. That's not what we're talking about. What we're talking about in the rental approach is analyzing what did come out, the value of what did come out. It's not fanciful. It's not pretending in a counterfactual world. It takes as given what did come out, and then asks the question, what is the Anishinabe's share of the value of what did come out? Mr. Hutchins.
So a dispute is I'm so worried about using the word value, but the dispute is what revenue to attribute to the resources extracted. So
That's right.
Direct, not only the direct revenue, but those other factors which Professor Stiglitz attributes that bring him to this definition of rents.
That's right.
That are included in the definition.
Right, and I believe Ontario's experts, I think as well, have recognized that while it might be very, very difficult to create a real world situation where you tax resource rents 100%, it's the most in theoretical terms. Even I think Professor Bodway writes in some of his writing about how that is he agrees with Professor Stiglitz, I think, that that is the least distortionary way of figuring out what your resources are worth, to calculate it based on resource rents. And when we talk about, there's really two, and I'll just re-emphasize it. You've got the actual direct resource rents that the Crown took out. And let's suppose they say, we've got a stumpage fee and we're taking out $100 in stumpage fees. But the value, Professor Stiglitz will say, of what they received is not just the $100 in stumpage fee, because the value of the resource has within it not just the stumpage fee, because if the stumpage fee should have been $200, then that difference between the 100 they took and the 200 that they should have taken is the resource rent that they should have taken. And that $200 is the true value of what should have been taken out.
And so when the words could have produced, one does not go back to, there were more trees to be cut, or there was more nickel to take out.
Right. So the could have, it's not the counterfactual world of cutting more trees to maximize the revenues. It's about could have charged more for the trees that it cut. It's a big difference. And one that doesn't, I didn't think, it didn't come intuitively to me when I read the reports. Mr. Hutchings will also explain why the expenses considered by the Crown's experts are incorrect and why his figures are more correct. Mr. Hutchings will then explain how each of the nominal amounts he calculates for the period up to 2019 are properly brought forward to March 2020, which is about 3 years ago now. He will also provide various bring forward calculations, which are already included tab A. So you have the range. Finally, he may address some of the issues that Professor Stiglitz may not get to in his testimony. And that leaves us with our next witness, Dr. Paul Dribbin. Dr. Dribbin is an ethnohistorian who has spent the better part of his life studying the Lake Superior Anishinaabe, and he testified in stage 1, and he has been called to opine on 2 issues in this case. Firstly, he will provide guidance on the Anishinaabe perspective with respect to the expectations of the parties, both parties, at the time of the treaty, that sheds light on how the parties would have identified the appropriate share of the wealth that should accrue to the Anishinaabe. He will explain that the Crown shared the Anishinaabes' view. And the answer he arrives at, perhaps not unsurprisingly, given Anishinaabe culture, is not a set percentage. It's an amount that is consistent with the Anishinaabe principle of Mino Bemadzowin, or the good life. That phrase came up in stage 1, and you're going to hear more about it in stage 3. Dr. Dribbin concludes that the appropriate share is one that achieves a result. So going back to 1850, you might remember that shortly after 1850, there was a petition from Fort William in 1852, and they didn't complain, give us a set percentage. They complained that this is the famous Fort William petition. They complained that what they were getting was not in keeping with what they expected, and they then extolled the Crown to give them what they need, give them their due, give them what was promised. So it's a result and not a percentage. So he will explain that the good life is not simply a moderate livelihood. And, that moderate livelihood standard is what comes from the Marshall case and the lobster fishing. It's not that, but it is to be as well off as other non-Aboriginal people. This approach actually echoes the income gap approach, which the Court of Appeal seemed to favor. Dr. Dribbin will also speak to the history of the populations of the Robinson Superior Anishinaabe from 1850 onwards. Now, this evidence remains necessary for two reasons. Firstly, the population from time to time remains relevant because even though all of the 12 possible treaty First Nations have agreed amongst themselves to share in any award, and if you'll remember tabs 6 and 7 of the stage 3 trial record, which is the intervenor orders, identifies how that sharing is to take place. Unfortunately, the respective populations of each of the 12 bands remains an issue because the Crowns have refused to confirm they do not take issue with how the award is to be divided. They have not articulated what their position is with respect to the allocation of any global award. And while they have no expert evidence on the subject, I'm afraid the issue remains. It was an issue I tried to solve before today, was not able to do it. So technically this evidence remains relevant and we wait to see whatever the Crowns will say. Second, in order for the experts to calculate the disparities in outcome, the income gap approach, a population base is needed for the Robinson Superior Treaty Area from time to time. Dr. Dribbin provides some anthropological guidance on this point because missing for the period from 1850 to the 1880s are many of the First Nations populations that are before you today. In other words, Dr. Dribbin is going to explain that even though they weren't counted by the Crown, there were in fact more people present and more people in existence who need to be counted. And if you're going to do an income gap approach, you need to know what the population was. Which brings us to our next expert. Our next expert is Dr. Simona Bignami, a demographer. Again, I was unable to secure agreement with the Crowns as to what the populations were from time to time. Dr. Bignami holds a master's degree in demography from the London School of Economics, holds a doctorate degree in demography from the University of Pennsylvania, and she has 20 years of experience in developing and applying demographic methods. Currently, she's an associate professor of demography and is the director of the research group on Indigenous demography at the University of Montreal. So well qualified to sort of give us some guidance on what the actual populations were. And again, because the actual populations from time to time remain relevant, her testimony will focus on providing guidance as to the actual Anishinaabe populations from time to time in the treaty area. In brief, those persons who were not properly counted by the Crowns still existed. And in order to properly do the calculations on the income gap, the population counts provided by Canada needed to be adjusted to reflect the true population numbers. Her conclusion, and I'm really paraphrasing her conclusion, is that the actual historic population of the cohort of Robinson Superior people is about 20% greater than the numbers recognized by Canada. And she comes to this approach, I mean, it's kind of, I think it's easy to follow. She basically says, well, if the population on any given date in Canada's numbers is correct, let's assume that some numbers are correct, and the numbers that are most reliable are the ones that have removed the discriminatory aspects of the Indian Act. If you look at those numbers and you know demography and you know birth rates and the like, you can do an analysis of how much people there must have been in the year before. And you can do it for the year before and the year before and the year before. And depending on the growth rates, and she comes up with a range of a low growth rate and a high growth rate, because you know, she does the best she can with the data she has. And so it's about a 20% difference. The next group of witnesses you will hear from are the lay witnesses. You will hear evidence from Robin Superior chiefs and elders about deprivations and the need and the use that compensation would be put. They will explain that the compensation being sought is not being sought for individuals. The court will recall that consistent with the original intent of the annuity, and this goes back to the 1844 Bagot Commission report, the annuities were principally intended for the corporate development of the First Nations. You will hear evidence from these lay witnesses explaining that the compensation is for a people to help them heal, to help them help themselves, and to help them become independent and to achieve Bemadzewin. You will hear evidence that the compensation sought will be used to fund investment, both investment in themselves, investment in the greater Canadian society. The money that they would get would fund programs and build and sustain strong institutions and infrastructure, both on and off reserve. You will hear the lay witnesses explain how compensation would fund cultural programs serving not only the band membership, but others who choose to make use of those benefits. Benefits that many of us who do not live on reserve take for granted. Safe, up to code, non-moldy housing, clean, reliable water, cheap energy to heat our homes, economical food choices, and things like a healthcare facility, a recreational facility, a marina, a shopping mall, a bank branch, a swimming pool, a library, all things presently wanting in many First Nations. You will hear these lay witnesses speak of Anishinaabe culture, traditions, and values. You will hear of their tradition of saving and investing for the future, and of their cultural tradition of reaching out for advice and guidance on matters beyond their area of expertise. I want to remind or hearken back to the Court of Appeals concern about an award leading to great personal wealth at the expense of others. This is not what we are asking. Investing by the Anishinaabe does not lead to great personal wealth of the Anishinaabe at the expense of others. It leads to equality. True, the investment needed to achieve true equality of opportunity is more than what might be needed had there been ongoing payments in the past. But that is what is appropriate and that is what is needed. The compensation to be paid needs to achieve substantive equality for the Robinson Superior Anishinaabe. Things such as equality of health, equality of the opportunity, equality of hope, and equality of happiness come to mind. And here I want to turn to tab D, which I thought was a good graphic of substantive equality. And we have three people standing on boxes. They're all being treated equally, but the poor little person standing on his equal box needs a leg up. He needs two boxes in order to watch the game. And so this is a really good graphic example of substantive equality and the need to invest in those that have been marginalized, to allow them an equal, fair opportunity to participate in Canadian society in the future. And that investment is not going to be a bad investment. You're going to hear evidence about the value, and you'll hear argument about the value of investing in the Anishinaabe, because success for the Anishinaabe is success for all of Canada. A strong and resilient Anishinaabe nation strengthens the fabric of our nation, and the result of this court case will help facilitate that. I think now would be a good time to break, actually.
I have almost just after 12, so is a 1:30 return doable?
Yes, the 7 says yes.
Then we'll do that. We'll break now and return at 1:30. Thank you all.
This court will recess until 1:30. Thank you.
Can I have a look at this during lunch?
This court is now resumed. You may be seated.
Thank you. Good afternoon. Before I move on to my concluding remarks, I am pleased to report that during the break, there has been some progress, as small as it is. I spoke to my friends about how we should mark the plaintiff's opening statement, and the Crowns have agreed and identified that my opening statement should be receiving a mark of A, as in Exhibit A for identification. And I wonder if I, by consent, if I could enter it that way.
So we will have lettered exhibits in the show.
Yes, I think this is the first lettered exhibit, Exhibit A, for the opening statement.
Just one question with respect to entering exhibits. Is the best practice to have the paper copies or email electronic copies or do both?
I wish I was the best.
How large are the paper exhibits going to be? I'm concerned, because anything that's in real form will be stored here under lock and key, and I just need to make sure that what I'm locking up, I can lock up with what I have.
Oh, well, if that's the restriction, we
We can work with that.
can expand that.
Okay, that's my only hesitation is how it's going to be stored. Other than that, I enjoy paper exhibits.
Okay, paper it shall be.
You said even capacity.
Electronic. It would be on case lines, and then you would make a separate bundle called exhibits, and then there would be a way to stamp it on case line.
What the case lines function.
It is.
You might deal with that. Okay, thank you.
Yes. Before the break, I had finished off with reminding everyone that success for the Anishinaabe Nation is success for Canada and strengthens the fabric of our nation. My concluding remarks are going to have some concluding remarks, and I'm going to speak to the relief requested as best as I can speak to them today. The majority of the Ontario Court of Appeal confirmed that the treaty creates a revenue sharing model and cited with approval this court's finding that a plan to share the wealth on an if and when basis through an augmentation clause was always central to the understanding the aspirations and intent of both the Anishinaabe and the Crown. Now, regarding the past, the quantification of adequate and just compensation cannot, in this case, depend on the policy choices that the Crown alone made. They made those choices in breach of their duty to engage in the process, together with the Robinson Superior Anishinaabe, to determine what wealth would come into existence and how that wealth would be shared. Those policy choices were made without regard to the interests of the Anishinaabe. And to accede to that argument would be to permit the defaulting party to eviscerate the purpose behind the promise and leave the Anishinaabe with what has been called in a number of cases an empty shell of a treaty promise. It would permit the crowns for themselves to determine what revenues to realize from the natural resources, what amount they are, without regard to the interests of their treaty partners. Respectfully, that is not reconciliation, nor is it honorable conduct. Regarding the future, the Crown's,
Excuse me.
yeah.
Mr. Schachter.
Yeah.
Um, When I asked my last question about where the difference was in the economic theory, when one talks about the value of the rents,
yes,
the difference that I understand talking about is that the superiors are urging this court to accept is the difference in what, for example, one could get in stumpage fees, $1 or $2, as opposed to the number of trees.
correct.
So then when I see that you say to determine for themselves what revenues to realize, I wonder, and maybe sometimes that is what confused me, whether that is broader than what I have just described.
Yeah, it is broader. You see, in the counterfactual world, what should have happened is there should have been a process and a consultation about what trees to cut and when and how much. But when it comes to compensation, I want to be clear, we're not asking to go to that. We're limiting our claim to compensation to what was actually cut and the value of what was actually cut. We are not going to the counterfactual world of, had you consulted us in 1855, we would have said, leave these trees alone and cut all of these trees, right? So your question is a good one. But so in the counterfactual world, the perfect world, we would have been consulted, and we, the Anishinaabe, would have been part of the decision-making about what trees to cut and how much to charge for each tree cut. In the world of compensation, we are limiting our claim to compensation to the value of the trees that were cut. It's a good question and an important distinction to make. And I hope that answers your question.
Yes, and I'm just going to go back then and read what you have as paragraph 108, second sentence. It would permit the crowns to determine for themselves what revenues to realize to accede to their art would be to allow the crowns to determine for themselves
Right,
what revenues to realize.
right. And on that one, let's take the example of the trees that were cut. And to allow to the objection here when it comes to compensation is to say, look at if Ontario or Canada chose to realize 2 cents a tree when the proper charge should have been 10 cents a tree, that's not right. So that's what we mean by the measure of compensation is geared towards that differential. I hope, and I apologize if my opening is not clear, and I hope that my answers to your questions do bring clarity.
No apology needed. This is very helpful.
Okay. Regarding the future, the Crown's current vision of the implementation of the treaty annuity augmentation clause remains antithetical to the spirit and intent of the treaty agreement made in 1850. Unfortunately, it speaks loudly as to the bleak prospects that await the Anishinaabe in the future. And those bleak prospects are, from Ontario's vantage point, 1%. While courts understandably would prefer parties to negotiate rather than litigate, if this court fails to provide concrete guidance and direction as to the future implementation of the augmentation promise, at least to some extent, the Anishinaabe stand to be left out in the cold. The past 175 years provides no comfort that any negotiations with the Crown would result in a fair result for the Anishinaabe. With respect, the Crown has broken the trust so critical to the treaty relationship, and understandably, it will take time to heal that rift. Given the position taken by Ontario in stage 3, I am concerned that there can be no assurance of any healing on the horizon. I might say that looking at Ontario's present position, there's a sense of deja vu all over again, to quote from Yogi Berra. It's similar to the approach the Crowns took in stage 1, but this time with a more polished twist. In stage 1, this court observed that both Crowns rejected the proposition that they have duties of disclosure or consultation in the implementation process. In stage 1, the Crowns argued that the court should permit them room to exercise their discretion. Now, this court rightly rejected their submissions and found that the court cannot, and this is a quote, the court cannot simply accept the Crown's acknowledgement of their duty of honor and permit the Crown to carry on without further direction. And that's right from the stage 1 reasons at 492. Now, the problem we're kind of facing in practicality is that in this stage 3, the Crowns will argue earnestly and with the greatest of sincerity, I am sure, that they have taken the stage 1 decision to heart, and their current position respects and accepts their responsibility to diligently and purposefully implement the treaty augmentation clause in accordance with the honor of the Crown. I expect both of them to come up and tell you that. Now, the problem is that whatever is decided in respect of the past, when it comes to the future, the Crowns will seek little in the way of binding direction for the future implementation of the treaty augmentation. They will again ask the court for the space to negotiate and the space to exercise their discretion. With respect, the Crown's newfound and professed embrace of the obligation to implement the treaty in accordance with the honor of the Crown is reminiscent for me of the cautionary tale of the fox guarding the chicken coop, but with a twist. Imagine, if you will, a proverbial 173-year-old fox finally in court to answer the claim for the theft and conversion of some chickens and all of the eggs from the chicken coop that the fox had promised to guard. Well, in speaking to the claim, the fox turns to the judge, got egg all over his face, and in the most reassuring manner and calm tone that he can muster, says, "Look, Judge, firstly, about the eggs, there are none. So I don't know why the chickens are complaining. And as for the missing chickens, Judge, no one has to worry about anything. After 173 years, I have become a vegan. As a vegan, I can assure you, leaving me in charge of the coop will pose no cause for concern. You can rest assured." Well, Madam Justice, speaking for the chickens, we are not at all assured. Therefore, in answer to the main issues raised in this stage 3, the appropriate relief, which relief we believe the evidence will support, is as follows. And what I've tried to set out is my best, at this point, understanding of what the evidence, where the evidence ought to lead us and the proper relief. And it is the following: some declaratory relief that the defendant Crowns are jointly and severally liable to implement the terms of the treaty each to the extent of their jurisdictional competence, a declaration that they're jointly and severally liable to pay the compensation, a declaration that they've both breached the treaty, a declaration that both crowns breached the duty of diligent implementation of the treaty, a declaration that both defendants breached the treaty by failing to engage in the process required in stage one. And I want to pause there for a moment. The stage one decision was 2018. It's 2023 right now. There's been no stay of the order, and there's been no process. Both defendant crowns should also, there should be a declaration that they must forthwith facilitate and engage in the process, because they haven't to date, and we require an order directing them to do so. I appreciate they've appealed to the Supreme Court of Canada, but that doesn't stay the requirement to engage in a process. So we've lost 5 years of cooperation trying to figure out what the how to deal with the net crown revenues. 5 years of data that could have been kept that has been lost. So in keeping with the Anishinaabe principles, I want to turn to the quantification of past compensation. Admittedly, there are significant ranges. However, right now, the best data that we have, that I have seen among the experts, is that the appropriate share is 84%. And the true and genuine lost opportunity of the Anishinaabe to share in what the treaty promised, the prospects, the value, the potential of the treaty territory, is the 3.58 billion nominal amount Stiglitz and Hutchins identify. The evidence will show that I want you to, maybe this isn't in my paper part, but the evidence is going to show that the 3.58 billion is extremely conservative in all respects. You will hear evidence that although in theory the resource rents should try and capture a portion of taxes on goods, taxes on labor, and taxes on profits, we don't try to do that. So the measure of value we take is a muted conservative value of rents. In keeping with the Anishinaabe principles of sharing, therefore, the appropriate calculation for past compensation that I believe to March 20th, 2020 best approximates a fair and just loss is 84% of 3.58 billion as identified by Stiglitz and Hutchins and brought forward at an appropriate interest rate. And Stiglitz and Hutchins explain, and we endorse their views, that the 60-40 equity to debt portfolio is not only actually conservative, but also realistic in this case. As for
That
the,
ends up to be the 7.2.
that, no, that, if you actually do the math, that ends up being $126 billion at 7 point.
I was just saying the rate.
Oh, yeah, 7.2%. Yes. Yes, I thought you were talking about nominal amounts. No. But you can see that, you know, if you only use 5%, it's only 27 billion. And if you use 7.2%, it's jumps to 126 billion. That's the magic of the time value, right? As for the future, while it's difficult to predict the future issues that may face the parties, based on the past difficulties, including those that are arising in this stage 3, there is respectfully little comfort that the crowns are really ready to embrace the relationship that the treaty calls for. And here's the thing, until that time arises, as I've sort of thought through this, what principles for the future are going to keep people's feet to the fire, to the sense of making sure that they take the treaty relationship to heart in a way that they haven't so far. And those principles are that I could identify, which I would confess, I'm not sure that they're the totality of everything that makes sense, but I thought it made sense to say that for the future should hold the following. Absent agreement to the contrary, all crowns are jointly and severally liable to the Anishinaabe to make the annuity payments required. Secondly, I think that beginning in the fiscal year ending in 2020, because we got up to 2019, and again, absent agreement among the treaty parties, the Crown's discretion as to what Crown resources-based revenues are realized by them and what expenses are appropriate is theirs to make. So absent agreement, leave them having the discretion. But the price of that is that they have to deal with the losses, the amounts each year based on annual resource rents for what they could have been. So this is, I think I'm trying to give a trade-off, an incentive to the Crown to sit down in a meaningful way. And it's kind of like a negative option, right? To say to them, look, this hasn't worked for 173 years. So unless we come to a different conclusion, you have to pay for value on a go-forward basis. We're prepared to talk. We'll be there. You're our treaty partner. But each year you're going to have to pay value unless we agree otherwise. And that to me doesn't seem so unfair, because that to me is very true to the core of the treaty bargain. And I want to try and stay true to the core of the treaty bargain. I then have provisions in subparagraphs 3 and 4 about how they have to provide information by August the 1st of each year for the previous year about what the Crowns think should be paid. And then they should just pay that. They should pay it. And if we disagree, we can come back to court, but they should just pay it. They shouldn't be able to say, since we disagree, we're not paying anything. And the fifth point, I'm trying to find a way that's palatable to the Crown to encourage prompt payment. And what I say is, maybe what's reasonable is that any amounts unpaid in the future, after the amounts become due, should calculate interest at the same rate that the federal Crown's own Canada Revenue Agency department imposes on Canadians. Tit for tat. When a citizen owes the government money, it's a set rate by CRA. It's a relatively high rate, but if they're going to not pay the Anishinaabe, then it should be a similar rate. Now, in part 6, I talk about how the Anishinaabe can go back to court to seek whatever order is appropriate at that time. At paragraph 7, I make the point that the annuity payments due each August should be dispersed to the First Nations who are beneficiary bands for the whole of the previous year, and should be dispersed to each beneficiary band in the same proportion as each band's population bears to the total population of all Robinson Superior Treaty bands. That is pretty much what is agreed to in the intervention orders. Thank you, Ms. Lewis. And is consistent with what happened in 1850, 1851, 1852. And again, absent agreement among the parties, the share for the Anishinaabe should be the 84% called for in Stiglitz and Hutchings. And of course, we would want judgment for all amounts due and costs. In closing, the path to reconciliation cannot lead to a dead end. The result advocated for by the Crowns in this stage 3, unfortunately, leads us to a 1% dead end. Ontario's vision remains an impoverished vision of the ongoing future treaty relationship, and that does not bode well. In contrast, the Robinson Superior Anishinaabe advocate for a meaningful treaty relationship, one where the compensation for the past and the principles for the future permit the treaty partners to realize the future opportunities and potential of the treaty territory in a manner consistent with respect, responsibility, reciprocity, and renewal, and the intention of the Crown to act honorably with justice or fairness and with liberality or benevolence. It is the plaintiff's hope that the judgment at the conclusion of this case will facilitate that vision. And if I might say, and just please forgive me for going to this, but it's irresistible. After 173 years of government neglect and inattention, it is only fair and just for the chickens to come home to roost. Couldn't resist it, sorry.
That was right.
That concludes my opening statement.
And shall I presume that you have handed up a copy? Thank you.
Thank you. May it please the court, I make this opening statement on behalf of the 7 added party plaintiffs that have been referred to as the Group of 7. It is my privilege to act for them, along with my co-counsel and colleague, Spencer Bass. The First Nations comprising the Group of 7 are Anambigu Zagagan Anishinaabeg, Bigdugong Nishnabeg, sometimes referred to as Pick River, Binjatawabik Zaging Anishinaabeg, formerly Rocky Bay, Bingwi Nayashi Anishinaabeg, formerly Sand Point, Long Lake Number 58 First Nation, Pace Platte First Nation, and Netmezagamig Nishnabeg First Nation, sometimes referred to as Pick Mobert. The Group of 7 are 7 separate First Nations and bands under the Indian Act, who are part of the larger Indigenous society known as the Anishinaabe. Their traditional territories are located north of Lake Superior in the area outlined in the text of the Robinson-Superior Treaty of 1850. But the Group of 7 are differently situated than the other Superior First Nations. And you've heard, of course, from Mr. Schachter on behalf of Red Rock and White Sand, and on behalf of the members of the Group of 3, comprised of Fort William First Nation, Gull Bay First Nation, and Michipicoten First Nation. All members of the Group of 7 maintain that they were not represented at the Treaty Council in 1850 and never signed on to the treaty, nor did they ever subsequently adhere to the treaty.
Can I just make sure I have those 3 points?
Yes,
Not represented at the Treaty Council, not signatories to, and did not adhere to.
that's correct, Your Honor. Thank you. Now, the Crown takes a different position. The Crown has consistently maintained that the Group of 7 are in fact parties to the Robinson-Superior Treaty, and the Crown and its various emanations has treated them accordingly. At various points over the last 170 years or so, certain members of the Group of 7 have been paid annuities under the Robinson-Superior Treaty. Now, that being said, of course, this trial is not about the Group of Seven status under the Robinson Superior Treaty. And the question of whether these bands are signatories to the treaty or adhere to it is a distinct question that is in the process of being resolved in another forum. For the purposes of this case, the Group of Seven were added as plaintiffs in order to protect their contingent interest in augmented annuities if they are subsequently determined to be parties to the Robinson Superior Treaty. And I'd like to make it clear at the outset that in this trial, the Group of Seven supports and adopts the position of Red Rock and White Sand, including the expert evidence to be adduced by Red Rock and White Sand regarding the value of the territory that was surrendered or said to be surrendered by the Anishinaabe parties under the Robinson Superior Treaty, and the Crown resource revenues and expenses from the territory, as well as the share that is due to the plaintiffs as compensation for unpaid augmented annuities over the past 173 years.
Can I just check with you here on one point?
Yes.
Here to protect their contingent interests if they are subsequently found to have been signatories or to have adhered.
That's exactly right. Yes, Your Honor. Thank you. So therefore, and this may come as a relief to the court, I do not wish to speak extensively about the numbers, figures, or calculations that will feature prominently in this trial. I will not be taking you to tab A of Mr. Schachter's opening address. Instead, I wish to speak about certain concepts that were of deep importance to the Anishinaabe people at the time when the treaty was signed in 1850, in the 173 years since, and today. These concepts have formed a central part of the perspective of the Anishinaabe parties to the treaty. It informs how they would have understood the promise of the Crown to share in the value extracted from their lands in the form of augmented annuity payments.
Let me see if I've got that. They say today, you say today, that they did not sign and did not adhere. But had they been there, these concepts would have informed their perspective.
That's correct. That's correct. And undoubtedly, it's my position that these concepts, and there are really two of them, that they informed the understanding of the Anishinaabe signatories. And in this respect, I support what you have heard and will hear from the Red Rock and White Sand plaintiffs. Now, the first concept is the principle of sharing. And as the majority of the Court of Appeal explained in the Stage 1 appeal, and this is at paragraph 290, at the most obvious level, the concept of sharing was built into the augmentation clause. At paragraph 293, the court elaborated, the treaties were an agreement to share in the value of the territory. And one of the central tasks for this court in this trial will be to determine the extent of sharing that was promised by the augmentation clause of the treaties. Or in the words of the Court of Appeal, the form, level, and aim of the sharing that the augmentation clause requires, and that at paragraph 323 of the Court of Appeal's decision. And of course, I recognize the court's been through the treaty interpretation exercise in Stage 1 at length, but to state what may be the obvious by now, as with any question of treaty interpretation, interpreting the sharing promise in the augmentation clause requires choosing from the various possible interpretations of the common intentions of the parties, the one that best reconciles the interests of both parties at the time the treaty was signed. And of course, that's the Marshall decision of the Supreme Court of Canada, and at paragraphs 14 and 78. So this exercise, of course, must have due regard for the perspective of the Anishinaabe treaty parties. And here, of course, the groundwork has been laid. It's been laid by this court, and it's been laid by the Court of Appeal. And some of this has been touched on by Mr. Schachter, and I will be brief. As the majority of the Court of Appeal outlined, drawing on this court's findings in stage 1, the Anishinaabe were not focused on subsistence in the treaty negotiations, but on sharing the wealth. They sought the ability to live as they had so long as possible, but also sought to benefit from the rise in living standards that would accompany development, especially if that development impaired their traditional way of life. They were not aiming at mere subsistence, and that at paragraph 319. The majority went on to say that the common intention of the parties was to share in such a way that would provide for both communities. That at paragraph 322, and the court will take my point, that must mean both the Indigenous and non-Indigenous communities were meant to share for the benefit of both. Thus, the appropriate level of sharing must be determined with reference to the relative wealth and needs of the different communities. And in my submission, we must also consider the question of sharing against the background of what this court has already decided about the Anishinaabe perspective and the Treaty Council of 1850 in stage 1 of this trial. And I take the court, Your Honor, to paragraphs 419 and 420. Paragraph 419, at the Treaty Council, Chief Shingwakons, Chief Podesha, and other Anishinaabe leaders fully understood that they were providing the Crown with access to and administration over their land for the purpose of Euro-Canadian settlement and development. They were giving the greatest gift of all, the land and water over which countless generations of their ancestors had presided. The source of Bimadzuan, that is to say, life in the fullest sense of the term. At paragraph 420, the Anishinaabe chiefs and leaders had every reason to expect that their gift attracted a reciprocal gift commensurate with the value of what they had provided. And that takes me to the concept, and already touched on by Mr. Schachter, Mino Bimadzuan. Now, the group of 7 submits that crucial to the Anishinaabe perspective on the sharing promise is this concept of Mino Bimadzuan. In Anishinaabe Bowen, it means living the good life or the way of the good life. And we expect that you will hear a great deal of evidence about this important Anishinaabe concept throughout this trial, both from experts on the Anishinaabe perspective, such as Dr. Dribbin, as well as from Anishinaabe chiefs and elders themselves. I expect that you will hear how this is a foundational concept in Anishinaabe law and culture. It informed the establishment and implementation of treaty relationships. As a result, this concept and the ability to ensure the opportunity to pursue Mino Bimadzuan would have been prominent in the minds of Anishinaabe signatories to the treaties. You will hear from Dr. Dribbin about how Mino Bimadzuan represented the good life, that an Anishinaabe person aspired to follow, including emotional, physical, mental, and spiritual health, and a concern for the individual and collective welfare of all living things. through giving up their land to the crown, something that they viewed as incredibly valuable to them. The Anishinaabe viewed the annuity and the augmentation clause as allowing their communities to obtain the way of the good life through the share of the value of the land that they would receive. In Dr. Dribbin's expert opinion, the Anishinaabe signatories believed that through the augmentation clause, the Crown would consider their wants and needs and take care of them in the way that a father would take care of his children, enabling the Anishinaabe to secure their futures and the good life. Thus, in entering into the treaties in 1850, including the augmentation clause, the Anishinaabe believed that the treaties would facilitate their communities as well as the Crown in pursuing Minnow Bemadzuen. Yes.
Entering into the treaties in 1850, the Anishinaabe believed.
They believed that the treaties would facilitate both the indigenous and non-indigenous communities in pursuing, and I'd say achieving, Minnow Bemadzuen. And importantly, respecting the concept of Minnow Bemadzuen, you will also hear the perspective of a number of important Anishinaabe witnesses, including Chief Duncan Mashano of Big Dagong Nishnabeg, one of the group of 7, Chief Marcus Hardy of Red Rock First Nation, Chief Wilfred King of Gull Bay First Nation, and Chief Patricia Tangi of Michipacotton First Nation. They will discuss what Minnow Bemadzuen means to them and the members of their communities. You will hear from them about how the concept of Minnow Bemadzuen is a holistic concept that applies not just for today, but includes future generations. It includes all aspects of Anishinaabe living, such as health, wellness, mental health, culture, identity, and language, economic sustainability, access to lands, resources, a healthy environment, food and clean water, spirituality, humor, and yes, laughter. Consistent with the findings of the majority of the Court of Appeal, the augmentation clause and Minnow Bemadzuen go beyond mere subsistence. In giving up their land, the Anishinaabe did not believe that what they were getting in exchange was a small proportion of its value, something that would simply allow them to barely sustain themselves at best. I anticipate that the evidence of the Anishinaabe witnesses will support the expert's opinion that while Minnow Bemadzuen is not a quest for wealth or simply to obtain the greatest amount of wealth, it does require adequate material resources. Specifically, Anishinaabe people require resources to satisfy their immediate needs and enable them to dedicate themselves to pursuing the higher goals of the good life. They will discuss how increased annuity payments over the past 150 years could have been used by the Anishinaabe bands to facilitate their members achieving Minnow Bemadzuen. In particular, I anticipate Chief Mashano will discuss how increased financial resources from augmented annuities would have given his people greater ability to exercise many of the other rights that were protected by the treaties, all of which require some financial resources, such as harvesting fish and moose, trapping beaver, and otherwise exercising their rights in the territory, and therefore enjoy the good life. Now, however, instead of being able to utilize augmented annuities to facilitate the good life, these Anishinaabe witnesses will discuss how their communities suffered deprivation, especially when contrasted with the non-Indigenous peoples who live in the treaty territories. Rather than facilitating their pursuit of Bino-Bimazuen, the Anishinaabe have been forced to watch others enrich themselves on the fruits of their traditional territories. They have watched non-Indigenous people come onto their traditional territories and settle on the land. They have seen workers from large companies run by non-Indigenous people cut down the trees, dig mines, and take away the valuable fruits of the territory and ship them on trains and boats and trucks far away. They have seen the profits and other revenues go to Toronto, Montreal, New York, and beyond. They have watched the gold of their lands, both literally and figuratively, bring great wealth to others. Well, they have seen their people struggle in poverty, while their annuity would barely buy a cup of coffee. I expect that you will hear from various chiefs who will testify about the deprivations and struggles that their communities have suffered relative to the non-Indigenous population of the treaty territory and the rest of Ontario. You will hear about the conditions that their people have faced for generations. You will hear about the vast income gap between Indigenous and non-Indigenous people in the treaty area. And Your Honor, this result is starkly inconsistent with the promise made in the treaties in 1850. The Anishinaabe understood the treaty's promises to enable both sides to pursue and obtain Bino-Bimazuen. However, in reality, only one side has been able to benefit from the manner in which the augmentation clause has been implemented. And indeed, if you could use the word implemented at all about the implementation or the augmentation clause since 1875. So to conclude, in the past more than 170 years, the Crown has not honored the promise made to the Anishinaabe in the treaty. Canada and Ontario have not shared the wealth from the treaty territories in a manner that would facilitate their Anishinaabe partners obtaining the concept of the good life, Bino-Bimazuen. Instead, the Crown has enabled the benefits from the territories to accrue to the non-Indigenous inhabitants of the land, while their Anishinaabe partners have suffered significant deprivations. Yes.
Crown has allowed the benefits of the treaty or of the land?
From the territories to accrue to the non-Indigenous inhabitants of the land, while their Anishinaabe partners have suffered significant deprivations. That's the proposition. And so I say that this trial is an opportunity. It's an opportunity to correct this historic and ongoing wrong, to return to the Anishinaabe what they were promised all the way back in 1850, but never received a share of the wealth taken from their lands sufficient to enable them to pursue the good life. And finally, it is important to always keep in mind that this trial is not just about the past. As Mr. Schachter, my friend, said a moment ago, it's also about the future and repairing and renewing the relationship between these treaty parties. To that end, the plaintiffs also seek declaratory relief to ensure that the augmentation clause of the treaties, which are meant to last in perpetuity into the future, are diligently implemented, going forward in a manner that is consistent with the parties' common intention when it was initially signed. That is, in a way that facilitates the attainment of Minnow Bamadzewin by the Anishinaabe signatories. And Your Honor, subject to any questions, that is my opening statement. And I understand that it might be received as a lettered exhibit, and I think it would be B. Thank you very much.
Very nice, thank you. And can I just presume that you will give exhibit B to? Did you say
Yes,
you have it?
I think I've done it. I think
Oh,
I've
okay.
provided it in hard copy, and I think I've distributed it electronically, and my friends have it in both forms.
Very nice, thank you very much.
Thank you.
The hard copy I received is the one that.
I, unless there is anything that should come today, my understanding from your post schedule is that we have achieved everything we meant to.
I wonder, tomorrow, I don't know how long Ontario and Canada are going to be, whether we should do 1 day each, or whether we should, there's time for them to do their openings tomorrow. I'm at their and court's discretion. Matters not really to me, but whatever works for everybody else.
Well, I think I asked this once and was told very clearly that they each did a day, but do you propose any change to the current schedule? Ms. Evans? Ms. Barton, Ms.
It
Andrews?
is hard to estimate how long I will need, although I am going to change my submission somewhat to be more responsive to the openings I've already heard. And in effect, I think mine will be shorter than I originally intended. So I'm thinking probably about 3 hours. I think that's sort of comparable to the submission today.
Ontario's contemplating also some minor.
We will follow Canada. That's, of course, Canada's position against us. Depending on what I hear from my friend, we currently contemplate being at 2 hours, maybe a little.
My only question is, do you have any interest in trying to squeeze in tomorrow, or you prefer to go Wednesday? That was the schedule, and I'm
Go on Wednesday.
no, we had a schedule. I'm quite content to go with what we've got, unless there is a joint movement to change it. So, so we'll call court for the day. I'm going to stay. I'm going to, if others want to stay to work with issues that I have about this room, I don't know whether I need close on that end or open here, but I'm going to stay for a bit. I'll close court and we will resume tomorrow at 10. Thank you all.
Oh yay, the sittings of this quarter now concluded. Long live the king. Thank you.